50-year-old man who looked like he was 75, and had the worst of life. That's what he looked like. That's what he was.
On June 3rd, 1961, Clarence Earl Gideon was arrested in Panama City, Florida. He was charged with breaking and entering into the Bay Harbor pool room. Reported stolen some wine and change from the vending machines. Gideon maintained his innocence. He had no money for bail, so he was kept in the county jail for 2 months awaiting trial. He had no money for a lawyer either.
Every case in a state court where there was a death sentence, the state court was obliged to furnish a lawyer to a defendant who was too poor to hire one. In addition, you're entitled to have a lawyer appointed if there were special circumstances such that you could say it was unfair, unjust for this defendant to have been tried without a lawyer. And there were no special circumstances in Gideon's case.
I'm sorry, but I will have to deny your request to appoint counsel to defend you in this case.
The United States Supreme Court says I am entitled to be represented by counsel.
Let the record show that the defendant has asked the court to appoint counsel to represent him in this trial.
Even though the Supreme Court had previously said that states did not have to provide lawyers to all defendants too poor to hire their own, Gideon, who had never had more than an 8th grade education and no formal legal training, was convinced it was his right.
I always believed that, and I thought that was actually a law. I thought that was a constitutional right, and I didn't know no different. No man with money can hire a lawyer to represent him. He'd get a better chance in the trial than I would get without an attorney. So to me, that was just common sense. There was no argument to it.
On January 8, 1962, an envelope from Clarence Earl Gideon arrived at the Supreme Court of the United States. He asked the Supreme Court to review his case
on the grounds that I was made to stand trial without the aid of counsel.
In response, the Supreme Court decided to hear Gideon's case.
And since he was indigent and didn't have a lawyer, it was a practice of the Supreme Court to appoint a lawyer to represent him on his appeal.
They appointed me attorney, Mr. A. Porter.
So from having no lawyer, he had the best lawyer in the country.
You know, being appointed to the Gideon case was probably the best plum that any lawyer has ever been given. I think every lawyer in the country would have grabbed the chance to be appointed to represent Gideon. And if someone had said, Bruce, you can either represent the state or make the argument for Clarence Gideon, obviously I would have taken Gideon's side of the case.
Bruce Jacob was an assistant attorney general of Florida. The boss, the attorney general, gave him the job of arguing this case in the Supreme Court. He didn't expect to win. Nevertheless, he went about it in an extremely serious, dedicated way.
Bruce Jacob requested the other 49 state attorneys general to write amicus briefs supporting Florida's position. The Attorney General of Minnesota led the charge, but not as the state of Florida might have hoped.
We decided to solicit those same attorneys general on the side of an amicus brief that would say it should be a national legal principle that a right to counsel should be provided. We got a lot of support for it. This was new. This usually didn't happen. States would just duck on issues like that. In this case, 22 states said, no, this should be changed.
On January 15, 1963, the Supreme Court of the United States heard the case of Gideon versus Wainwright. On March 18, 1963, the Supreme Court unanimously ruled in Gideon's favor and held, against previous precedent, that the Constitution entitled Gideon to the assistance of a lawyer in his defense.
Well, I felt great. I received a telegram from Mr. Fortress congratulating me on the decision.
Even though the Supreme Court reversed Gideon's conviction, he did not go free immediately. Instead, he was given the opportunity for a new trial, this time with a lawyer.
It showed that the difference between not having an attorney and dealing with an attorney.
If you need for us to represent you, please fill out the application form this morning.
Ms. Field. Okay. All right. The first page. Please, if you got a question, please have a seat and we'll get your questions in just a moment. We got to keep this organized or we're going to be here all day.
When you are in court every day, facing pressures to process a lot of cases through the system, a public defender who is standing up saying, slow things down. I need more time to investigate. I need more time to look into what's going on here. Rather than seeing that as a lawyer who is living up to their constitutional obligation, it is easy to see that person as an obstructionist. And so I think the pressures in the system often drive players in the system to value efficiency and speed over justice, which actually can be time-consuming. It's a very dehumanizing system.
All right, what's the facts and basis for these fees, please?
I really do believe that you judge the character of a society, the commitment to the rule of law in a society, the civility of a society, not by how you treat the rich and the powerful and the privileged, but by how you treat the poor, the incarcerated, the condemned, the accused. It's in that context, the only context in my view, that you can really measure our commitment to the rule of law, our commitment to justice. And when you look at these cases where we're tolerating such bad lawyering, inexcusable lawyering, embarrassing lawyering, we're saying a lot about our commitment to justice. We're saying a lot about our commitment to the rule of law. And we're saying a lot about our values and our norms.
So help out, speak up, be a force for justice.